Hello, great people. Welcome back to our channel. The case of Bola Tinubu and Atiku Abubakar with Peter Obi has entered another phase in the Supreme Court. Some few days ago, Bola Tinubu had written to the Supreme Court to reject any fresh evidence brought in by Atiku Abubakar. But the fresh evidence has so much power, and what it will do might go an extra mile to either strip Bola Tinubu of his position as the president, and in Atiku Abubakar, the position as the next in terms of positioning in the election. So right now, there is a secret legal battle going on. Let me give you full details of what is currently going on in the Supreme Court. Now, according to the news, the 2023 presidential candidate of the People Democratic Party, PDP, Atiku Abubakar, has asked the Supreme Court to jettison technicality and grant his application for leave to tender fresh evidence to support his case against President Bola Tinubu. Recall that Atiku had filed a notice of plea before the Apex Court alleging that President Tinubu submitted a forged document to the Independent National Electoral Commission (INEC) to contest the February 25th presidential elections. Atiku predicated his plea on the grounds that presenting forged documents by any candidate, especially by a candidate for a higher position in the land, is a very grave constitutional issue that must not be encouraged. But President Tinubu asked the Apex Court to dismiss the plea to grant Atiku leave to present the fresh evidence on grounds of jurisdiction, and that the issue of qualification is a pre-election matter among others, and subsequently pray the court to deny the grant of the application. However, in his reply on the point of law, Atiku, while faulting Tinubu for his objection, submitted that issues of merit ought not to be determined or pronounced upon at the interlocutory stage. Atiku stated that they are only at this stage merely applying for leave of the Supreme Court to receive the fresh evidence submitted, that to refuse to grant the leave, as the respondent have argued, will amount to undue technicalities. In his word, and I quote, he said, "The Supreme Court, as the Apex Court, and indeed the Policy Court, has intervened time and again to do substantial justice in such a matter of great constitutional importance as it did in the case of Amechi versus INEC 2008, feed NWLRPT 010822227, and OB versus INEC in 2007, 11th PT 1046565. The Supreme Court applied the principle of ubi jubi reminum to ensure substantial justice is done in such naval scenarios. The need to rebuff SQ and reject technicality and the duty of court to ensure substantial justice is very germane in this matter, given the gravity of the constitutional issue involved in deciding whether a candidate for a higher office is in the land. The office of the president of the country presented a forged certificate or not. In urging the Honorable Court to overrule the objections of the respondent, we can do no better than to commend to your noble lordship the insightful words of the Supreme Court in ASA and ORS versus Kara and CORS 2014 LPELR-24212 SC Rodis Vigor GSC as follows. Law is blind, it has no eyes, it cannot see. That explains why a statue of a woman with her eyes covered can be found in front of some high court. On the contrary, justice is not blind, it has many eyes, it sees, and sees very well. The aim of court is to do substantial justice between the party, and any technicality that rear its ugly head to defeat the cause of justice will be rebuffed by the court. In a 20-paragraph affidavit, the deposed to in support of the application. Atiku argued that if the apex court grants the application, there would be no need for any further argument other than the written address in support of same, showing that the second respondent is in violation of the provision of section 137 subsection 1 I of the Constitution by presenting a certificate disclaimed by the institution from where he purportedly procured same. He further argued that Tinubu objection to admit the new evidence was baseless because he was represented both at the discovery and the deposition as well as at the court hearing by his Chicago attorneys, and that he never challenged the issue of venue of the discovery and the deposition. Atiku also faulted Tinubu's submission that he was inconsistent in his name, describing the submission as immaterial and pedestrian as there is no petition challenging his qualification. Besides, the former vice president pointed out that the presentation of a false certificate disqualify a candidate for all the time, no matter. Nice one there from Atiku, but it's important for us to remember that even as you wait for the Supreme Court to do justice and disqualify Tinubu based on the evidence that have been brought before them, we must not also forget that the issue of forgery is not the only issue that this article is bringing up. He has other issues that he's been bringing up. But then it is important for the Supreme Court to maintain their stand when it comes to their president. The Supreme Court must regain back the respect of the judicial arm of government. And that can only happen if they maintain consistency. One judge in Enugu cannot be saying another thing while another one in Katsina State is saying a different thing. Both of them are having different interpretation. Another judge will be interpreting the law in a completely different way, and this other one here at this other side, instead of him to align with the judicial president, he says it the way it fits him. We must understand that the law must be interpreted to the letter, not introducing your own meaning, because that is one of the issues that we have seen thus far in this current election petition tribunal. You will see that most judges, they introduce their own meaning while they are supposed to uphold the intention of the drafter of the law. That's exactly how they are supposed to deliver justice, not to try to twist it anyhow they wish so that it is very okay for themselves, not accepting that there is a precedent that they must follow. For example, if we look back at what happened in Enugu State, how can someone forge his own certificate and then a judge will have the audacity to open his mouth and say, yes, this particular candidate, yes, he forged his certificate, but the certificate is not a requirement to contest for governorship? That is actually totally contrary to all the judicial precedents from the Supreme Court. And whenever that happens, automatically the respect of the Supreme Court is depleting day after day. I think that the judiciary at this point would do what is right. Now, the reason why I'm emphasizing on the issue of consistency is because of some of those things that have happened, for example, in Enugu State, and even the latest one that happened during this guy's case, the senator that they just kicked out, Senator Elijah Abo, where because of dependency on electoral law, they deducted some of his results, which made him not to score the kind of score he needed to have to win. And the victory was given to the PDP candidate. And unfortunately, this is the same appeal court that would throw away everything that Peter Obi and the Labour Party, including Atiku Abubakar and PDP, brought at the presidential election petition tribunal. Going through their judgment, they never recognized the fact that it was bound by the law for the INEC to upload results in real time. They forgot about all the infractions or that was committed by the INEC. While in another appeal court, they had to consider all those things. These are some of the things that will make judiciary to lose their respect. I feel that the Supreme Court at this point need to take cognizance of all these things and align to the judicial president so that they can restore back the dignity of the judiciary. I think I've spoken enough. Let's meet in our conversation.